Good evening, friends. Welcome all. So, we all know that Insolvency and Bankruptcy Code Amendment Bill 2025 is introduced in Lok Sabha on 12th of August 2025 and is pending with the Select Committee of Parliament as of now. So, I'm pleased to inform you that IPNet is initiating a series of webinars pertaining to the proposed amendments. We understand that already a number of webinars are held on this very topic, but what we present to you is entirely different as we try to explore the legislative intent behind these proposed amendments, as well as the practical implications, or I would say key implications of the same on the entire IBC ecosystem. So today's webinar is the first webinar in the series of webinars we have planned. It's my pleasure to welcome you all to today's webinars, which is IBC Amendment Bill 2025 Key Implications. Now, I would actually welcome Mr. Parag Singhal, and I would want him to show the certain videos regarding the IPNet and its initiative and contributions.
Thank you, Sandeep ji.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Okay, thanks, Paragji. Is it all?
Yeah, thank you.
Okay. So now I would like to invite Mr. Arvind Saxena to introduce the guest speaker, Madam Harmeet Kaur. She happens to be company secretary as well as the IP. Mr. Arvind Saxena, over to you.
Mr. Saxena, are you there? Okay, I'll take the charge. Friends, IP Harmeet Kaur has 2 decades of industry experience in the corporate secretarial, legal and financial areas in the sugar and green energy sectors globally. She has worked in the insolvency and bankruptcy field since September 2017. And I hope Harmeet is also listening. She has worked in the insolvency and bankruptcy field since September 2017 and has worked on multiple assignments under IBC and provided consultancy and advisory services to IPs, RAs, COC, etc. She is currently practicing as company secretary and process advisor to various stakeholders in IBC. She is also empaneled as an independent director with the Indian Institute of Corporate Affairs. She has graduated from Shriram College of Commerce and has done postgraduate diploma in business administration and computer application. Friends, she is actively working as a consultant and trainer in the Posh Act and company law matters. Friends, I now invite Harmeet to take over the discussion from here.
Thank you so much, Parag ji. I am very much here listening to your kind words. Thank you so very much. Thank you, Sandeep ji. Thank you, Udiraj ji. And thanks to all the participants who have joined just on time. I'm thankful to each of you. And let's hope we have some wonderful discussion on the much awaited amendments that have been proposed. This has been in discussion since 2022 because all of us are aware that last set of amendments came in 2021. That was immediately hurriedly carried out at the time of COVID, and those reliefs were granted on 4th April 2021. Those dates we all remember now. 1 lakh to 1 CR, MSME, pre-pack, all that came in 2021. But thereafter, in spite of all the practical difficulties that we were having, only the regulations were being amended. Regulations are still being amended every alternate month. We see some amendments, sometimes even twice a month, there are amendments in the regulations. That gives us a path to, change the manner in which we conduct our procedures. But important is the entire process requires some changes. So here we are with the changes in the process, most of which are emanating from the discussion paper of 18th January 2023, and thereafter certain more amendments have been carried out. So let's see through. And as Sandeep sir also informed that there shall be a series of webinars, and till now most of the webinars which we have attended on the amendments are only talking about the from the bird's eye view of majorly covering all the amendments. So here we are taking up slowly and in detail about each of the amendment, the legislative intent behind that, and the practical implications thereof. And I would invite your comments or suggestions or experiences thereon, if only they are related to the context that we are talking about, because that should not disturb the flow of the entire forum. So you can interrupt me wherever you think that you have something to say or ask related to that particular section or amendment that we are talking about. So here we start with the proposed amendment, which aims to, even the amendment bill itself says, Mrs. Nirmala Sitharaman has herself said that it aims to reduce delays, to maximize value, to improve governance, entire process of all the processes in the code. And it also seeks to modify the existing provisions to align with the overall objectives of the IBC. Overall objectives are quite clear, the preamble is quite clear, and all of us are working towards achieving all of them, and any changes shall only be aiming to align with them. New provisions have been introduced to follow the global practices also, especially in resolving the CIRP and not in the liquidation, the global practices for resolving. So let's go through the CIRP related provisions only today. I have only touched upon the CIRP provisions, and later in the series, in the coming weeks, we will be having more sessions on the rest of the amendments that have come through this bill. So initiating this with changes in section 7, I am not taking up the amendments in a sequence of the bill itself. So it is not in a sequence. I'll tell you why, because the context and the subject that we'll be touching about, I have taken all of them together. So it will be easier for us to understand the concept, why it has been introduced, where all it is touching us. So important here is that the existing provisions and the 2025, I'm calling it IBC 2025. So existing is 2016. So let us quickly see that red is being changed, green is the amendment, and blue is the impact, which is there on the next screen. So I have presented it in this manner so that you don't need to go through the entire small font of the subject today. So section 7 says that existing section 7 says that AA shall ascertain the existence of default, and thereafter it may by order admit such application, and all the other ingredients of section 7 shall remain the same. So what does the amendment say now? That it shall within 14 days of the receipt of application by an order admit the application. So that is a welcome change, and I understand all of us would appreciate that, because it is, we all can say this in for this thing in this forum at least, that delays are mostly happening because of lack of infrastructure at NCLT's part, whatever the reason may be, but delays are happening there. So this small may to shall make some difference. Other changes are some explanations have been added to it, that in case the IU has been updated by the financial service provider or the financial institution or the applicant under section 7, that shall be a sufficient proof for the NCLT to rely upon and to admit the application. And there shall not be left and right approaches given to the ascertainment of default, right? And another explanation is that no other ground shall be considered to reject once the default is there, then it shall be admitted. So this is a welcome change, and this makes it mandatory for the NCLT also after a certain point, with given a clarity on the admission of default, ascertainment of default, then it shall be maybe quicker, and in case of any delay, they have to give reasons in writing, all that it was already there. And it also talks about our preparedness, like some of us may be giving consultancy to the or maybe we are providing legal services for filing the applications. So our applications should be foolproof, because now we are aware that there shall not be any further chances given to ascertain the debt and default. So once they are there, the application shall be admitted. Section 9 also has similar kind of changes. Only corrective measure has been brought in as respect to the language. So only one place language has been changed, and I would like to invite someone to guide us on what makes a difference between prescribed and specified. So that is the only change that has been made in section 9. If anybody would like to say something about it.
Yeah, madam, prescribed would mean by the government rules. Specified means this is the regulations.
Yes, so there was a mistake in this section. It was talking about as may be prescribed. Rather, it should have directed to the regulations. Regulations means whenever the code says about specified, that should mean we should refer to the regulations. So here, such other information to be annexed along with the application as may be specified by the board. So it is only about the correction in the language. Changes in section 10. So now section 10, some very important, one very important change has been made, and all the language changes are only to bring about that change in practical. Important change is that the RP, the IRP name shall not be proposed by the CD itself. Already section 10 applications, I find them to be difficult. I find their filing to be difficult. I find audited financials of immediately prior 15 days date financials a difficult practice, a difficult requirement to be fulfilled for filing an application. But you must be noticing over the past few months, there have not been any admission of section 10 applications. So the legislative intent and somewhere the indication from the Honorable NCLT itself was that this might be misused. This might, is being misused, that is why the applications were not getting admitted itself. So now when the mandatory requirement of giving the name of the IRP is removed, and the resultant changes have been made in the section wherever they were coming. So I think now the path will be paved, and the applications shall start getting admitted hereafter, because already it was a difficult task to file the application. It was a difficult and long task to get them admitted. And now, although theoretically, one may think that when a company itself is going and saying that I am insolvent, I cannot pay these debts, and this is the proof. So it should theoretically it should not be a difficult process to ascertain the debt and default when the company itself is saying I'm unable to pay. And that is the situation of insolvency when the application should be admitted. But here, since the misuse was very evident and अपना RP लाएंगे का चल रहा था in the market, so it was necessary to plug the situation, plug the loophole here, and it is. I understand that this is necessarily a correction and additional reporting accountability. The neutrality of IRP appointment shall now bring more confidence by the AA also in the system, the COC also. It recused the scope of manipulation of the process by promoters during interim period by getting a favorable IP to be appointed as IRP.
Harmeet, I just want to add here.
Yeah.
So with my through my experience, actually, I recently got one assignment wherein this was a Section 10 application, and the IRP was proposed by the CD. So now this very IRP is changed by the financial creditor, who happens to be the sole financial creditor. So you rightly said that there was actually there is an intent behind this very thing, that now they have plugged this very loophole that IRP cannot be proposed by the CD. So now this has been plugged, and accordingly, so now this will be, I think, taken up from the panel of NCLT maybe. So what they intend to do as of now. So moreover, regarding Section 7 and Section 9, so I would like to just add a few words here. So it is actually now there in the amendment, proposed amendment, which says that if the admission will be delayed by adjudicating authority, then the reason for delay has to be pointed out, or maybe that has to be recorded over there. So now this is additional pressure on I think, the adjudicating authority.
Yeah,
Yes.
let us see whether there is any pressure on them. Already they are under pressure, I understand, but
Yes, yes.
this
Yeah,
adds to
Sandeep, I have a counter on your views.
Okay.
A Section 10 or Section 10 case obviously comes in the picture when there is a default. It means there is a financial creditor, and they have the wisdom to continue with the RP, or they have the power to change the RP. Therefore, putting the blame on the RP proposed is a corrupted or he is having an intended intention is absolutely wrong. You are proposed for a company, and do you mean that you have underlined idea with them and you are going to manipulate something which I cannot accept? 1 second, let me complete. Let me complete.
But the financial creditor has the right.
Let me complete. You know, I file a writ petition and all those things, right? Now, under Section 7, IPs are appointed, recommended by the financial creditor. Sandeep, we had a long discussion on all these things when this IP, bank empanelment, etc. is happening. How many people are get empaneled, and out of empaneled, how many are recommending? Only the people who are getting the assignment is keep on getting assignments. So, means, does it not have any intent of intended interest? I have cases where financial creditor used IP for his own interest rather looking into the IBC code. So these recommendation cannot be. The biggest problem now, Section 7, Section 9 appointment. 1 second. Section 9, but let me put my concluding word. Section 9 appointment, Section 10 appointment, if it is given to NCLT, well, I am happy. But you have to see the atrocities happening in NCLT. For example, Mumbai having 7 NCLT bench. The whole list of 160, this one, empanelment is bifurcated into 7, and it is given to 7 NCLT. In Chennai, there is 2 NCLT. This whole list will be segregated and given to 2 NCLTs. And Delhi is 5. You know, many such bench may be handling the company's matter. In such case, he never going to get a assignment. Okay, and
so
there is no mechanism.
We can have a separate practical session on this.
Let me say.
We should continue with this one.
Let me say, concluding the word. Okay, so when NCLT is not having clarity on the appointment of IP, putting these changes is nothing to do with the best benefit of the IBC ecosystem, this is what I want to register, whether it is accepted by the people or not. From my
Let me-
experience, this is
let
what
me
I
say
will
Vinodji, your
something on
views are,
this, sir.
you-
Vinodji.
sorry, Jay, your views are well taken, but let us now continue. We can have a separate practical session on this. So these deliberations will go on and on with no result in sight. Yes, Mr. Madam Harmeet.
On this subject, let me add one thing on what Vinodji has said. Getting the assignment, granting of assignment, that is a separate subject altogether. How the NCLT shall select the RP from the
Yes,
panel,
certainly. So
that is a separate subject. So we are
that
only
is
talking
a
about
procedural
the law
matter.
mandate.
I do agree it's a separate subject. There
Yes.
itself is
So let's-
atrocities are going on and
We are
assignments
not
are selling off.
discussing those.
Okay.
Yes.
Assignments are selling off. Okay.
Sir.
For handsome. Okay.
So that is okay.
And
That is okay,
Come
Vinodji,
back
but
to the theory of it.
this is a procedural matter. So
now
procedural matter
procedure,
cannot be.
when this procedure is recommended, correct? So there is big anomalies. That is what I just want to register. I
Yes,
don't want to take
there
and
are
I
maybe
want
such problems in the
yeah, I
ecosystem.
don't want to
Yeah.
waste much of
Yes, can we please move ahead with the topic?
Yeah,
Thank you.
please.
Yes.
We have to move ahead. Thank you, Vinodji.
So, the section 11 important change here is the introduction of chapter 4A. So I'll quickly take you through the creditor initiated insolvency resolution process, which has just been introduced in this draft. But we will see the detailed creditor initiated insolvency process in one of the sessions, which will be dedicated only to this subject. So I'm just quickly taking you through what creditor initiated insolvency process shall be. It has been introduced in section 58A, and thereafter there is entire 58 section on this. Just like pre-package, we had 54A to K. So here it is, creditor initiated insolvency process may be initiated in respect of those CDs where a CD with assets or income both below such levels as shall be prescribed and notified, a CD with such class of creditor or such amount or such other category of CD as may be notified by the central government. So this is still open, but there is another branch of insolvency process. Just like an innovation had been made in pre-pack, similarly an innovation has been made in the creditor initiated insolvency, and we shall definitely have an entire session dedicated to this subject. So that was the only change in section 11, and persons not entitled to make application shall also include persons who are undergoing chapter 4A. There are certain other new concepts also, which are not part of today's presentation, but I have highlighted them because we are talking about the creditor initiated process. Similarly, the fast track CIRP was not practically possible and implementable, so that has been removed from the code. The government is empowered now to prescribe rules for group insolvency, and they shall be coming up with the rules regarding maybe common adjudicating authority for the entire group, maybe common RP, joint COCs, etc. to happen. So those rules are still awaited. The cross-border insolvency new enabling provisions have also been introduced in this bill, and we have not yet taken up in today's session, and we will definitely take up each one of them separately via a dedicated session on them. So coming back to our CIRP section, so another section is 12A, and this is a major change that has been brought in to plug the loopholes. And the intent of the government here is to reduce the situations where the entire process has been misused, and the CIRP is admitted just to take advantage of some maybe a promoter or supplier, or a situation wherein the negotiated amount of settlement can be enhanced, such this has been used by certain OCs and certain creditors just to increase the money on the table. So we all have seen certain cases where the settlements have immediately happened after the admission. It did not happen throughout the admission process while the application was filed, while the application was admitted, but during that process, the negotiations and settlements could never be agreed upon. And immediately on admission, it happens so fast. So that has now been plugged. Two time zones, two timelines have been assigned to the settlement. That is before the constitution of COC, the application shall not be withdrawn. So this is a major change. Regulation 30A will have to be majorly amended for this purpose. And after the first invitation of submission of resolution plan has been issued by the RP, after the Form G has been published, thereafter the settlement shall not be possible. So this will save the time and energy and resources of the entire system and the stakeholders and the professionals involved therein. So
Harmeet,
this is also a welcome change.
Harmeet, it means, so this is the limited window which is available to withdraw the application then?
Yes, sir.
After constitution and before first
G.
invitation.
Yes, and I think this is a very important change that has been brought in, and most of the professionals shall agree. We keep waiting for some, admission to take to happen, and within 2-3 days it is, settled thereafter. While we are not aware, while we may not be aware that what is going on between the promoter and the applicant,
Yes.
whether it has been self-induced or what has been the motive behind, but many cases have been settled within 2-3 days of admission. And I don't understand the logic behind that. How can they justify that settlement happening?
And the fact is, the
Let
entire
me-
dilemma lies with the IRP
Let
which
me
is
add,
appointed.
let me add something here. What
Yes.
had happened is there is an inherent provision under Rule 11 of the NCLT rules, which that application rules that allowed the applications to be withdrawn. That's a general provision under Rule 11.
Mhm.
What had started happening is initially, as soon as the matter was admitted, people used to stop the RP from doing publication. They used to go to NCLT and they used to try to get the matter disposed of immediately. But recently, what had started happening is the promoters would typically run to NCLT within 7 days, 4 days, 5 days. Immediately, there used to be a stay on the CIRP process and the RP used to continue. And I have seen matters getting settled before NCLT after 9 months, 10 months, even 1.5 years, and the matter used to be pending there. So this all was discussed in details in the famous case of GLS Trust Company LLC versus Baiju Ravindran. We call it Baiju's case. So in
Yes.
Baiju's case, this came up and it was very specifically stated by the Supreme Court that the provisions under 30A and 12A are not exactly to be followed in the way they are drafted. They say that once NCLT admits the petition, they become the proceedings in rem and not in personam. So they say that whether you form the COC or not, NCLT cannot do anything other than going back to 12A and 30A. Even if the COC is not yet formed, they say still all other creditors which might have been in the COC who have submitted the claim need to be heard if they object the settlement. So we have seen some cases after Baiju's wherein out of 10 creditors, only 4 objected, 4 got settled, balance did not get settled. And when they went to NCLT said, you could have objected, you did not object, even after Baiju's. And these all confusion was going on. So it was very necessary that now the 12A need to be set right, and the matter would be run in the interest of the stakeholders rather than as a money recovery mechanism. So that is the background behind the amendment in 12A. Now 12A is now very strict section, and as Harmeet ji has rightly pointed out, 30A will be required to be modified accordingly.
Thanks, Udiraji. So you rightly pointed out the legal aspects behind this very thing. But I just want, with my experience, I just want to add some things here. So like you rightly said that some of the creditors are settled, some are left behind, and there is a lot of litigation over there. So in one of the cases I'm handling as of now, so there is a precarious situation wherein actually, so after the receipt of expression of interest, receipt of EMD along with the expression of interest, and even going up to the stage wherein the resolution plans have been received along with the EMDs. And now this was before the COC for the finalization of the resolution plan. So the suspended directors went to the sole financial creditor. They approved his OTS. This was to come to me in the shape of 12A, and this 12A was to be filed. Form FA was to come in. But the thing is that somehow that could not be honored, but the right decision the financial creditors took at that very point in time, that the insolvency process will run simultaneously. If the OTS is not honored, this will go on simultaneously, and things will move on further. So, and that actually provided ground to me to run the insolvency process as it is. Finally, the OTS didn't get honored, and finally, the resolution plan is approved by the COC. So now, if that had the OTS would have been honored, and resolution plans are there, so that would have been a very precarious situation. So wherein there might have been a lot of litigations from the SRL or maybe the other maybe the applicants.
Creditors.
So yes. So then those litigations would have gone on because they have spent time over it, time and effort. Money is also provided. EMD is deposited. So that is another precarious situation.
So, at the same time, we have been seeing in the recent judgments also even at the NCLT level also, we have seen certain judgments where they have started indicating that the IRP must also acknowledge the creditors appearing in the books of accounts. So at one point, at one place, we are seeing that those creditors will have to be acknowledged and they should be mentioned somewhere, even if they have not filed their claims. And on the other hand, we are, only approving one application from one applicant who may not be having major stake in the entire creditor, entire list of creditors. So, and that too from the OC, though it was to be corrected only. This is majorly a correction of the situation. And one simple applicant cannot be, on the application made by one creditor and settlement made by one creditor does not resolve the insolvency situation of the entire company. So this was logically required, and it removes the scope of withdrawal by a settlement between one applicant and the CD. It limits the scope of application by promoters for withdrawal once they have an idea about the valuation. Thereafter, there is no going back.
Yes.
So,
That is the thing. That is the thing.
scope of misuse post-admission settlements.
So they get to know about the fair value. So then they just try to find out the liquidation value on their own. So then they actually go for maybe OTS kind of thing.
Yeah.
Sandeep, here also it is expected that NCLT will come across that this is not mandatory, it is regulatory, because the basic principles of IBC is to be honored. The preamble says it is not mechanism of recovery, it is resolving and restoring the company. Therefore, we are accepting the OTS even after the solution plan.
For resolving, it is important that all the stakeholders' interests are taken.
90% is accepting. 90% is accepting.
90% is accepting, then reliance will have to be placed on their decision making, sir.
Right. In that case, they may given an opportunity being heard.
No, but Vinodji, this is actually they are providing a small window now, starting from the
right, sir. But what will happen?
Formation
This
of
is not
COC and going up to the first invitation.
Absolutely, this is not going to end. You see, there will be NCLT will come across with a different direction.
All right.
You are there, I am there. We can expect, and that time I will make a message to you. Thank you.
Okay.
Okay. So
Let's see.
14, there are some clarificatory changes, and they were required because of some anomalies and certain applications being filed and creating a wastage of time and resources for everyone. So it has been explained that it is, especially they say explanation for removal of doubts, it is clarified. So the act itself is putting so much importance to this that it is a clarificatory provision that the provisions of subsection 1 shall also apply where the surety seeks to initiate or continue any action or proceedings against the CD pursuant to a contract of guarantee. It's not that they get the right to recover immediately on payment of a small amount or maybe the entire amount by them. Actually, the law is that they won't get the right of subrogation till such time they pay the entire amount. And even if they pay the entire amount, they won't get a right to recover the same from the CD during moratorium period. So this has been amply clarified by putting in within the section 14 subsection 1 ka explanation. So here moratorium again 14 will apply against the surety where it seeks to initiate initiate recovery proceedings against CD pursuant to its rights of subrogation in contravention of 14(1). If the surety has any claims against the CD, it should submit them during the process like other creditors. Another important change which we are now we can have a sigh of relief because abhi tak hum collate ko samajh rahe the. For years it has been we have to only collate the information and it was actually
Yes, yes.
logically not understood. And now it is very clear that yes, you also have to verify, not only
Verify.
collate. So this is a much needed change that has come now. IPs are all RPs are also equally RPs are also equally intelligent to determine the value of the claims, and it was only given to the liquidator. So the law was being interpreted in the true language what was given over there. So now it has been corrected. In my view, this is a correction.
So, Arvind, so what will be the implication going forward? So what can be a serious implication? So is it,
It will bring a positive change because the litigations that arise because of non-admission of claim, see, admission or rejection was not being practically done. Some RPs were following a scheme of accepting, rejecting, collating. They were not very clear on whether to verify. They were only checking the supporting documents and putting them in one column. So it was a confused state of situation. Now the IRP shall clearly lay down which claims they shall accept, which claims they can reject. And that shall be very clear in the list of creditors itself. Earlier, they were also hesitant to reject a claim. They were not to verify. They were not given authority to accept or reject. So in my view, Uday sir, if you can add something to this, because this has now brought clarity to the functioning of the IRP-RP.
but Arvind, on my part, actually, I was actually putting up certain columns over there on the IBBI website. Like I was admitting certain claims, I was rejecting certain claims, and finally, so what is actually admitted, this comes in the last column. So Udayji maybe will throw light.
We had become so cautious or over cautious that we actually used to say amount admissible, amount not admissible. We did not even used to say rejected because NCLTs would say, who are you to reject? So we used to say not admissible. So that cautious we had become. And if we would go and adjudicate the claim, though there was a provision that in case the claims were contingent or if the claims were not possible to be fixed, then the RP was required to give the best estimate. And the RP could admit the best estimate. So that was there, but it didn't used to verify for the stand taken by NCLTs in this regard. That also because of the language of the code and the regulation. Not that RPs did not want to do it. They always wanted to verify the claim, see how the claims are. So on one side, everybody was asking that, see whether the claims are in limitation or not, check the documents which are attached, but RPs used to stop at that point. And now the verification will be necessary. So RPs will be responsible to maintain some kind of an SOP as to how they have verified the claims. They will have to tick that if there is a mortgage deed submitted, they will have to verify it is correctly stamped, whether the charge has been created with the NCA or not. They will have to verify everything and then come to a conclusion that I have verified and now the claim is admissible to a particular extent. And if he is not able to, if the claim is not clear, then the RP has the, I would say, obligation to arrive at an amount, and he himself or she herself will be required to justify as to how did she arrive at that point. So all that responsibility has been now fixed on the IRP or RP. So I would suggest that some kind of an SOP should be developed in which you ask questions, take questions, and then do a 1-pager, 2-pager documentation on each claim as to what you dealt with, why did you accept, why you did not accept, and communicate to the claimant as to this is what has happened. So I think that will be necessary.
One more thing.
Sir,
there are two
May I
issues.
add one thing, sir?
I want to say something.
As per Swiss Refunds case, the IRP has only he has no quasi-judicial power. He has only the administrative power only.
Yes.
He has no right to reject. He has no right to reject the claim.
Yes. So that
if he
was
has any doubt,
Now it is very clear. We can also determine the value of the claim.
Yes, sir, that's all.
So some
If
of
any
the
doubt, we can.
some part of the claim can be rejected.
Harmeet ji,
Yes.
I would like to say something.
Yes.
Yeah, though the clarification has come, the role of the RP has been clearly defined that he has to verify. But practically, even in the earlier regime, in the collation, the list of creditors, amount accepted, rejected, and partially rejected was being submitted to the NCLT. List of creditors. Who was preparing the list of creditors? How they become? What is their voting share? So amount claimed, amount accepted, amount rejected. That exercise was being done by the RP. We cannot say the RP was not doing
What
it.
we are saying, sir, very well taken. That's what we are saying. Every RP had a different practice. Some were admitting, some were not. Some were saying admissible, not admissible. Some were saying collating. This is the list. These have filed, supporting or not. So we were inventing our ways of making list of creditors, you know. And now
So-
it is very clear. Because
So
they
moreover, actually, Harmeet, moreover, we were also checking that whether this falls under limitation or what. So this is also to be seen whether this
this
covers
is
under
also to be
limitation.
seen. Yes, that is
Yes.
our, that is
Uh,
anybody's
I-
job. Yes.
I think RP was doing only thing that now the clarity has come. Because if you reject any claim or if you not accept the full claim, it was being challenged in the NCLT. And
Yes.
NCLT was asking why you have rejected and why you have not accepted.
But sir, there were certain judgments which said very clearly that RP shall not admit or reject, and very clearly they said shall not verify. Verifying is not his duty. He is only collating because the language of the code was such, and it has
Collat-
now been corrected.
Okay.
Yeah.
It
Yes.
has
When
made
we-
more clear.
When
Harmeet,
we
one
talk,
more thing.
when
Just
we
a minute,
talk on
Vinod sir.
bond,
Vinod ji, ek minute, Harmeet, there are two issues that come to my mind so far as this particular amendment or this change is concerned. One is the timeline, time constraint that IRP is facing while he is issuing, verifying the claims.
Yes.
And formation of COC has to be done within such and such time after
Yes.
the publication of this invitation. So one thing is whether this timeline is extended or not, because collation is altogether a different thing. Verification is a vast, it's a Pandora box. It will be open once it is open.
Yes.
Now,
Because
second
you
is,
will have to write to the concerned person. You may have to ask for more documents, and in the meantime, your timeline is over.
yes. So
But
that
then
is going to be a
then
big issue.
there is a relief that claims are being filed perpetually now up till that time prior to the 15
No,
days time.
That's fine. But in case I get X number of claims and I don't verify it and make COC, then again it constitutes COC, then again it is a problem for IRP.
But
No, no,
constitutional
Pragati, there are
COC
there
has
is
to be
jurisprudence.
sacrosanct. There you cannot make mistakes.
Yes.
So, Pragati, there is jurisprudence. So, wherein actually says that one can actually revise the claims list till the time resolution plan is, or it is saying that RFRP is released. RFRP
Sir,
is released.
I fully agree with that. But my concern is that when as IRP, I am verifying and I am constituting the COC, then it can lead to a problem for IRP.
But
How?
I think that has already been taken care of by the change in the regulations when they say that whenever there is a change that tantamounts to change in the constitution of COC also. Even then, RP क्या कोई गलती थोड़ी ना है वहां पे. Claim
हाँ,
has
बिल्कुल.
verified within 7 days. You have made a change in the COC constitution itself, but the decisions taken in the past shall not be affected by that.
So in that
And
case,
you
in
are
Yes,
allowed
first,
to do
certainly, certainly. This
in
is
the
very
first
much true.
constitution
Yes.
of COC,
constitution.
one has to be
that is a challenge.
very high alert so as to include only the properly verified claims.
But sir, that too we are already doing. Constituting the COC के लिए तो मुझे नहीं लगता कि we are leaving any stone unturned. उसके लिए तो हम पूरा verify करके then only we admit them and.
आप कर रहे हैं, लेकिन it was not provided in the act. Now it is provided.
Yes, you are.
Second issue is,
Yeah.
once COC is formed and the entire process moves to RP. Now problem may arise. There might be some conflict between IRPs working and RP working so far as earlier verified claims are concerned. So RPs have to keep this in
No,
mind also.
in my view, the RP cannot undo the work done by IRP because that has also been seen in one of the judgments by AA very recently. Once the IRP has done a certain job, unless it is significantly, some material problem is discovered by the RP later on with the discovery of material event or something, or a apparent mistake, he cannot undo and change the list of creditors. That has already come by given by AA, and let's see practically how.
Yes, let us have the test of time.
Yes.
Yeah, Harmit ji, I have a simple question to ask.
Hanji.
When we reporting to IBBI the list of creditors, the columns appear amount claimed, amount admitted, right?
Right.
On the last end, there is a column called amount under verification.
Under verification. Yes, yes.
Now
yes.
now you please clarify me. It is hereby clarified that the interim resolution professional, while clarifying the claims, shall verify them, and if required, determine the value of such claims.
Yes. So that is why
One minute, my question is not completed.
Hanji.
So when I am doing this, okay, I verified, I valued, and I arrived at the amount of claim admitted. Some amount is come under verification. What is the timeline or what is the responsibility upon me to comply with the claim under verification?
So regulations are
I
yet to
can,
come.
no, my question, can I put the claim under verification for a long?
No, sir. We can take the indication from the 7 days window that has been given to the IRP. So when a claim is submitted to you, during the entire process, whenever a claim is submitted to you, you have to verify it within 7 days.
My dear Adalla, okay, everything is okay, but some amount I cannot reject. So I'm putting under amount under verification. How long I can keep it
Let me
under
uh,
verification?
Vinodji, that depends upon when the claim is put up to RP or the IRP.
Sir, what
So,
has happened,
so
sir?
7
I
days
would
time
just
frame
add
we take up.
something.
Sir,
The
the conflict start. A party can claim up to the RFRP, but I am not clearing his claim till RFRP. Then he can go and comply on me that this guy is not cleared this amount. He kept under pendency.
Because we must have informed to him about the deficiencies in the claim
Yes,
submission
yes,
document,
yes,
the
yes.
supporting
Yes.
document. Unless he clarifies, gives further supporting documents, if there is a deficiency, we cannot verify that yes, these amounts are tallying or they are there in our books of accounts. Then he will have
So,
to submit.
so we should not say that language we reject that, but this required clarification, documents, and all the things 1, 2, 3, 4, 5, 6
Yes.
kindly provide. Like that, we
Yes.
have to end up with. Otherwise, it will come boomerang back to us, right?
Back to
Yes.
RP.
So
Yes,
see,
very
Thank
we
you.
always
Thank you.
we always put the ball in others' court. So that is
Thank
always
you.
the safest thing to do.
Thank you.
I will add something here. The
Yes, sir.
practice of putting claims under verification is done by most of the RPs in goodness of their heart. They don't want to reject a claim. They have asked for information which they expect in good faith will come to them, and they put it under verification. But NCLTs have come heavily on the RPs in some cases where they say, what is this under verification? Either you accept or you don't accept. So that is very important. We have also seen some practice by RPs that just to complete the list of creditors, they will quickly accept some claims and some are put under verification.
Sir,
that
if I'm not
also-
acting, sorry.
So that all should be avoided as much as possible.
Correct.
And whatever we want to do, we want to get information, we write 10 emails and 1 month has passed, information has not come. Now, as Mr. Vinod has rightly said, it has boomeranged upon me that I have expected information to come. It has not come. 1 month has passed. What to do now? So such
So-
situation can arise. So that is one part. Second part I will want to tell is in the case of Hitesh Hasmukhlal Damania versus Manish Lalji Davda. That is a very recent case of 2025. NCLAT has very clearly held that RPs cannot suo moto revise the list of creditors. So that is a very important decision which has to be followed. So when we revise the list of creditor, the process has to be, we will have to go to COC, update the COC about it, take their view on it, because those claims might have been received before 90 days, very well accepted, but if there is change after 90 days, take COC's noting or comments on it, if possible take resolution on it, then file an application with NCLT that these are the changes which we propose to do and the list of creditors has also undergone change, kindly approve this, consider and approve this. That should be the approach in future. I am not trying to set a law, I am just observing what is happening out there and suggesting that this could be the best practice in future.
Sir,
Udayaraj
there is a particular
Udayaraj
state.
just Udayaraj
There is a
in that
particular.
case, Udayaraji, in that case, even the case laws which you have quoted and the claim under verification, it means RP was doing verification. Otherwise, without verifying, how can he say it is the amount rejected and accepted?
Anilji, we cannot say we were verifying because we were not allowed to verify. So even if we were verifying, we were not saying we were verifying. That is the fact. So काम तो कर रहे थे, लेकिन we could not write about it.
So it
NCLTs
means
have held collate. So we were collating, but while collating, we were of course verifying. But now it has been properly been
Said.
amended by way
it
of
has
an
been said, but we were verifying, sir. Otherwise, a financial creditor makes a claim of 1,000
Sir,
crore.
I'm a person who would follow the law. If law says I cannot verify, I will never say I have verified. While I will actually verify. That is how we have to do it.
Udayaraji,
What to do?
Got
in
it,
my
got it.
case,
Got
actually,
it, got it.
so there have been lot of communications with the with one of the actually claimant. So there have been maybe 6-7 emails to and fro, and this took a lot of time. So how would an RP maybe finalize that now 1 month has passed, this could not be finalized, and now this is to be maybe put under a different category of not passed, or maybe claim not passed.
I feel that whatever is the correspondence will have to be summarized in one final email, and without giving any further opportunity, you will have to write that this email was sent, your reply received, email sent, reply received, and which documents were still not received can be summarized and said that due to unavailability of these documents, we are not able to admit your claim and convey it to the party. That will be necessary because that one email, which is the conclusive email, will be useful for you in any litigation, because that person will do two things. One will possibly go to NCLT, and somebody who is more motivated may make a complaint with IBC also.
Sir, this happens with the government departments actually. They do lot of communication. So they, in one of the email, they will send, they will actually satisfy on 1 or 2 points, then another email, then another email, and they do not actually file their claims in a proper form, or they submit incorrect forms. So that is what is happening actually. So they do not understand the process and the legal part of it. So that is happening, and that takes time sometimes.
Okay. So verification has become mandatory now.
Yes, sir.
Yes.
So it was happening before also.
Officially.
Because we were doing verification of every claim which we received in any case, you know.
Chale, as I told, every RP had a different practice in this, but there were clear mandates from the cases decided by even the Honorable NCLT, Supreme Court also. Chale, let's move on to the next section, that is section 21, and the following subsection of 21 has been inserted. They say when the liquidation process of the CD is initiated, the COC constituted in the CIRP process shall continue supervising the conduct of liquidation process also. So this brings a certain level of, strict supervision. Earlier also SCC was somehow supervising and we were taking consultancy from them, and certain sections were applied to that, and the constitution of SCC, etc. We were taking care of all that. But now this COC shall continue and they will supervise the conduct of liquidation process and the liquidator. So some strictness has been provided over there. Even the change of liquidator replacement has also been included now. But today we are not taking up liquidation sections. It is only that in continuation of CIRP, the same COC shall continue. So that is the enhanced checks and balances system, efficiency in liquidation, and the confusion over who supervises the CD and RP while the plan is under consideration by AA. So the same committee people shall continue, and that will give some stability to the process, because a lot of time gets wasted in constituting the SCC again, constituting the monitoring committee. So some clarity has now come, and with the change in regulations supporting these clauses, we will get more clarity, and that will ease our procedures only.
I don't think that it will expedite the process, because COC usually rather will delay the process, and the number of days have been reduced, and the members who are representing the banks, institutions in the COC, they are not empowered to take any decision. They even seek extension for voting also.
Yes, they do.
Even for small matter, even for the
But
smallest
there's
possible matter.
there the RP or the liquidator will have to be, strict enough to give burden.
Whatever
Just like
you
Sandeep
can't be
said,
you can't be tough with your employer. They are the one who are giving
they are
you.
not your employer, sir.
No, practically they are. For
It is
all
up to
practical
your
purposes.
perception. It is up to your
Uh,
perception. At one point, you are also being considered the chairperson of the meeting where they are sitting. So only for approval of certain matters we ask them. Otherwise, we only inform to them. So
now COC will approve everything. So the
no,
process or timeline of the liquidation has been reduced to 180 days. And without the approval of the COC, liquidator will not be able to function. So most of the jobs will stay pending only.
let us see how liquidation.
That
No,
is what we are seeing in the
there is
COC.
some myth. Sir, dear
Let
sir,
me
I
add
don't know.
something.
I can't see
Yes,
your
sir.
name. You are confusing with the two things. Here, there is a simple change is made, though the change is already there in the liquidation regulation. It
Regulations.
is now bring into CIRP regulation to connect with the regulation.
Yes.
It doesn't change that the COC is going to sit as instead of SEC. SEC is continuing as such. So there is
No,
no problem for the
that
liquidator to.
change will also be
Yeah,
brought
yeah.
in now.
It is
That
just a
change will-
connection link, connected matter. It's not changing anything, constitution of the SEC and its power, and it's not also changing the overwhelming power of the liquidator. You don't worry, sir.
The
No,
name
some
has been
changes will
changed.
be brought in there, Vinod sir. Some changes will be brought in the liquidation regulations now onwards because
Ah,
Hanji.
it is not only the change of the name.
Yes.
It is not only the change of the
Even,
name. You are not saying
even
that
for the
the
committee of
word
creditor,
SEC has been replaced by COC.
Hanji,
So,
Udit.
I would like to invite Mr. Udairaj. So maybe if you can add something, sir.
I wanted to add something which is of very importance is then small amendment in section 240. Under section 240, IBBI has got powers to make regulations.
Mhm.
And there has been an important change that in clause 22, what has happened is they have added the words standards of conduct of committee of creditors and its members under clause SA. So there will be a regulation and possibly a better code of conduct which will be required to be followed by two people. One is the COC as a committee as well as its members while they are acting independently. So those timelines that we are talking about, IBBI could not do much about it. Now, I would not say that it is as good as a regulation, but at least binding standards of code of conduct will be implemented by IBBI and COC will be answerable to it. So let us
No,
hope
sir.
that COC will be able to come
The
back with time-bound solutions and etc. Little change I'm expecting
little
that
change, sir. What we have experienced, even the existing regulation prescribe that the fully empowered person should represent the bank. But what we see, a junior
No, sir.
officer
No, sir.
attending
No,
the.
sir. You're again wrong here, sir. I would tell you. I will not say you are wrong, but I would say that you are reading it a different way. IBBI is saying that a decision should be taken by the particular person in the meeting was a prescription by IBBI, while they had no power to prescribe. Now they have power to prescribe, and when they have power to prescribe, they will be able to implement. So that is the angle we should look at it, sir. I agree completely, Anil Kumarji, with you that yes, there was a prescription that they should come into the meeting prepared and all that and do meeting. But IBBI prescribed it without powers. Now they are prescribing with powers. So that will be so that will make IBBI more powerful entity. They can ask questions to
COC.
the COC and RPs should take I would say IB should take benefit out of this and monetize it appropriately when the standard would come out that IBB has prescribed this and you do it in so many days. When you monetize it accordingly, it creates some kind of pressure on the COC members and they do it very quickly. That is my experience.
Let us hope that they start behaving responsible because the guidelines, the code of conduct is still there. IBBI has issued the code of conduct for the
No,
COC.
but IBB has no powers, sir. That is what I'm
No
again
power.
trying to tell. Now they have powers.
Okay,
After
let
the
us see.
amendment.
Let us see they start behaving responsibly.
We always hope for the good, sir.
Yes, yes.
But
Yes.
sir, practically what happens is actually the financial creditor they always say that one can actually go for e-voting. So they leave it to their senior members or committee members.
Sir, that is a major loophole in the policies of the banks, which are not aligned with IBC. You know, our
And,
timelines are sacrosanct,
what
our
I'm trying to
timelines are
say,
defined,
what
but
I'm
their
trying to say,
timelines are not.
yeah, but this will remain so. They are not actually empowered to take decisions.
No, sir,
They,
I don't think this will remain in this manner only because a lot of hue and cry has already been created. A lot of representations have been made
Yeah.
even by the bankers themselves. They also understand that time is of the importance, immense value. And whenever the committee meeting will be held, the proposal will be placed there, or admission or rejection of the plan, maybe approval on a smallest of resolution of yours shall come from the committee. So that those
Yeah.
procedures are
So-
being highlighted inside the banks also. So those
No.
policies need to be aligned with the IBC timelines, and I'm expecting some
So-
positive change in that.
No, ma'am, we are expecting the positive change, but are we trying to say the RBI was not aware of the IBI guidelines of the
Sir,
IBC? It took 10 years for them to realize that they have to conduct responsibly. They are the ones who are delaying the process for
sir,
not giving decision. So RBI needs 10 years. So if RBI needs 10 years, then they are very
Chari,
proactive on other things. So,
let's not comment on that any further.
no,
Let's
that is, we have to
uh,
comment now. We have to be fair enough. We have
yeah.
to be bold enough to say
Sir, we create that
RBI is the
in our
no,
COC
the
meetings
real
with the
conflict
mind.
is, ma'am,
Yeah.
the real conflict is the COC says, the
Hmm.
bank say IBBI is not our regulator.
Hmm.
Our regulator is RBI. So RBI should have issued guidelines so that
Yes.
they follow it.
Yes.
Why
Chal-
to have this kind of
Anil,
confusion?
Anil ji, again, I will try to answer. RBI cannot do it because they are not empowered to issue any guidelines under IBC. In IBC, only those who are empowered under Section 238 and 240 can do it, government and IBBI. The regulator under IBC is IBBI, so they had to be empowered.
So
And
RBI
now
could
they are.
request IBBI. RBI could request IBBI to issue guidelines. There should be
Sir, we are
some.
nobody.
They don't
We
need
are
10 years.
nobody to comment upon that, sir. We are very
No,
small.
As
yes.
far
if we are
as my
nobody to
knowledge
comment, then
goes,
how the process will
both
be run?
the processes are being aligned, and I'm sure a solution will be there
Yes.
soon.
Let's hope for the best.
Let's hope.
Yes.
That is what we
All
can say
right.
as of now.
Anil
Yeah.
sir, we are all basking in the same baskets actually. जो problem है वो सबके साथ common है और हम वापस
So
अब
we
एक दूसरे के
should be
problem ही
able,
discuss कर रहे हैं sir.
we should be bold enough to say
Sir,
where the
bold enough
problem
to
lies.
say is a different thing. Having things as per the will and guidance of the government is a different thing. You are absolutely right that it should have been done. It is not done.
Then
That's
only
why
that,
these things are
then
coming.
only we will be, then only we will be able to adhere to the timelines, na?
You are right, sir.
You're
Your
right.
point is well taken, sir. Whenever we get the chance through IPNet, we'll put forward this point to the authorities. Thank you.
Thank you, Paragji.
Thank you.
All right. So next major change, as I call it, is in section 25. And I have clubbed certain sections behind this. Certain definitions have been introduced. Certain changes have been made in certain sections. I have pasted the entire section for the benefit of the readers here, but I'll highlight only those places where the change has been made, right? So section 25 talks about the duties of RP. And earlier, the language was to file an application for avoidance of transactions in accordance with Chapter 3, if any. Now, the amended section, this J has been substituted, it says that file an application to the AA in respect of an avoidance transaction or fraudulent or wrongful trading, if any. So the clarificatory change has been brought in, and this has come after a long battle of interpretational problems. Many courts have encountered and many judgments have clarified, and now most of us understand the difference between the avoidance transactions and wrongful trading. Fraudulent or wrongful trading is one concept and avoidance transactions is the other concept. It started long ago, but we took a lot of time in understanding what kind of applications can be clubbed, what should be filed via a different application. So now the situation has been brought into the system very clearly, and the IBC itself, the code itself is being amended. for making the things clear. So let's go back to the definitions where it has fundamentally the clarification has been brought. Avoidance transaction has now been defined for the first time. It says means a transaction referred to in 43, 45, 49, and 50. So fraudulent trading does not form part of the avoidance transaction. Fraudulent or wrongful trading means fraudulent or wrongful trading as referred to in section 66. So section 66 has two parts, 66(1) and 66(2), which respectively take up the fraudulent and wrongful trading and explain that in a different manner than the avoidance transactions. Avoidable and avoidance transactions can be avoided and reversed, but fraudulent ke liye a separate procedure, separate timeline, separate look back period, entire approach is different. So now this will be very clear for all of us. Most of the IPs by now have understood this concept, and this was an important change, a needed change, which has now been brought in the form of clarification at three places. One, the definition, and two, the section 25, and three, respective sections themselves. Let us see what those sections say. And another important change which shall form a fundamental to these changes, let us take up as it is, clause 11, section 5, subsection 11, where multiple applications for initiation of CIRP in respect of a CDR pending before the AA on the insolvency commencement date, the initiation date shall be the date on which first such application was made before the AA, right? So what will happen now? The initiation date becomes important. The AA, while admitting a matter for commencement of CIRP, may write the initiation date in that. It is still at May, but the initiation date has been defined. It is said that initiation date shall be the date. So we can easily determine that, we can easily highlight that, acknowledge that, write that in our processes. And what is the relevance of initiation date? Let us see. The clawback provisions are made. Oh, sorry, this slide had to be in blue because this is the implication slide. They have been made stronger to cover maximum period. I'll tell you how maximum period is covered. The look back period will now start not from the insolvency commencement date, but from the initiation date. And initiation date is when the first application under 7, 9 or 10 was filed. So filing of the application, कई बार फाइल करके छोड़ देते हैं. PIRP में तो अक्सर 4-4 साल applications filed ही रहती हैं. So now filing will also become important in CIRP process. Let us.
Amit, I just want to add here
Yeah.
that regarding the initiation date, it talks about the first application. But
Yeah.
the thing, if that very first application will be taken, which is not actually withdrawn or rejected by
Yes,
the
yes.
AA.
Yes, that
Yes.
explanation is also given here. I have not taken that out.
It could have been settled also. 12A could have been completed. So it's only those applications which are pending when the commencement happens. So
Yes.
the application has to be live
yes.
pending.
Ma'am, how we'll know the date of initiation? We'll know the list of all the petition filed because there
You
may be
will
different
know, sir.
benches.
In a particular CD's matter, you can get all the applications on the NCLT website itself. You can get to know the connected matters. You can get to know other applications on the same page.
Even if it is in different benches. Even if it is in
Even if it
different
is
bench.
different, it cannot be actually. CD के again CIRP initiate करने का 7, 9, 10 will have only one NCLT will have that jurisdiction. Only
One
there.
NCLT but different benches. One NCLT but different benches.
But sir, same bench. Acha. So you will get that in the case history of that company. You will get that on the NCLT.
So we have to find out that.
Most likely, once this provision is applicable, the
It should
NCLT
be.
shall start mentioning in the admission
Yes.
itself. Because
That should be there. That should come in the regulation that they should start the date of initiation. They should state in the order date of initiation. Otherwise, there might be error and omission on the part of RP, and the look back period will also vary.
Yes.
So Udayaraji, just one question here. Udayaraji, can you
Yes,
come
yes.
in? So just one
Yes.
question here. So like Mr. Anil Kumar said that there might be different applications that in different benches. So procedurally, so are those clubbed if let's say if one application is admitted, so or maybe are those actually clubbed in at one bench? So Is it
No,
possible
no,
or will it be
it is
done?
possible, but it doesn't happen many a times. We have
Okay.
seen applications filed by financial creditors being allocated to different benches at the same NCLT. So that unfortunately happens even today. So keeping the track of those applications will now become the headache of the RP.
Yes, that
As
is
Mr.
added.
Anil Kumar has rightly pointed out, I hope that in the symposium after the bill is passed, all the NCLT members go into a symposium and they are guided by capable and able, I would say, jurists as to what will be the effect of this and how they will be required to look into the matters, how they will be required to pass orders, etc. So we hope that they will be incorporating this clause of pending cases against the CD and the initiation date. If that is incorporated, it will be very helpful for the RPs, no doubt about it. If not, then it will be an issue for the RP. As Haramidji has rightly pointed out, we will have to access the CD's the portal on NCLT and find out which are the cases which were filed, which were pending anyway. We have to do that because while preparing IM, we will have to find out which are the cases pending. So anyway, that will be part of the duty. But if it is already there,
understand
yeah.
NCLT while admitting should and will be doing this because that is
That is
also
what we are expecting. That is we are expecting.
So Udayaraj, just one suggestion here. So through the forum of IPNet, can we just make a suggestion to the relevant authority so that once the application is admitted, so all the relevant applications have to be clubbed in that very bench. So
Yes,
if that
what can
suggestion
be
can be
done
put up.
is that is one thing, that transfer can be done. Another thing is while filing the reply, when the CD files a reply, in that reply they can make a statement about other applications pending. So that also can be suggested.
Fine.
Raji, you mentioned in the IP we have to give the details of the pending cases. But once
Yes,
once an application has been admitted, all other application gets stand dismissed. Infructuous, they become infructuous.
they do not necessarily get dismissed. Sometimes they are pending. Of course, they will get dismissed in due course, but
They are
when
infructuous now. They become infructuous. Already the one
but
application has.
the record does not get deleted, Anilji. I don't get what you're trying to
Yes, yes.
say. But the record will be there and we have to find the initiation date
Yes,
only.
the record will always be there.
But they are no
So
more pending now. Because they become infructuous and dismissed.
they have to be pending on the date of commencement of CIRP.
Yes, yes, sir. But when you prepare, by the time you prepare IM,
no application automatically becomes infructuous without passing an order by the court.
agreed,
So they
sir.
will be heard and then they will be accordingly.
But by the time we prepare IM, most of these are the earlier applications or CRP initiation application must have been dismissed.
How does it matter, sir?
No, we don't have to give detail of those cases.
No, sir.
Pending applications.
No, those don't.
We will have to find out. No, without finding, how will you know they are dismissed or not dismissed?
Yes.
But that initiation date has to be found out.
Sir, what will happen once an application is filed and that application is dismissed? Then another application has been filed which has been admitted. So we'll have to consider the application or initiation which has been dismissed.
No, dismissed application cannot be. Only those which are pending on the date of commencement will be considered for initiation.
Yes. If the application is withdrawn or if certain application is dismissed, then those won't be considered.
Initiation date will not be considered for that application.
Yes, only the pending ones which were ongoing on the same subject of admission, and one of them is admitted. The others will be settled in the due course, dismissed in the due course, will become infructuous by default. But the initiation date shall be, out of all those applications, the earliest one, which is still pending. So though two criterias, the application must have been filed out of all the applications, the first one, and that is still pending on the date of admission of one of them.
Okay.
So, all right. Let's move on and see how these two things have made a difference in our avoidance spectrum altogether. The avoidance transactions definition, the fraudulent trading, and the initiation date. So these three things are impacting section Of course, the avoidance ke sare sections, they are getting affected by this. Here, we used to talk about period of 2 years preceding the ICD. Now we will say period starting from initiation date and ending on insolvency commencement date shall be substituted. So related party ke andar bhi and unrelated party also. So the period during which the initiation happened will also be included in the look back period. Under all the sections, the same change has been made. So here in 46, only another change is avoidable. For the word avoidable, the word undervalued shall be substituted. Now that is a correction only. In certain sections of avoidable transactions, there was some correction needed as to the liquidator was only written, and now the liquidator or the RP, as the case may be, those corrections have been made. So all of these sections, 43, 46, 47 is a new section. I'll take that up. 49 and 50. All of them, the same type of corrections are made 2 years preceding the initiation date, right? Let us see what is 47. A new section has been given in place of substituting the erstwhile 47. Now, erstwhile 47 was talking about situations where undervalued transaction has taken place and the liquidator or the RP, as the case maybe, has not reported it to the AA. Then in that case, ये हमारे पूरा against था. A creditor, member or partner of the CD, as the case may be, may make an application to the AA to declare such transactions void and reverse their effect. So such languages have been corrected, and let us see what else has been corrected in this. Important is now the entire new subsection has section 47 has come. It says where a preferential transaction. Now it started with saying undervalued transaction. So there was a mistake here. Now all the avoidance transactions are covered under this. Preferential under 43, undervalued under 45, extortionate 50. Even the fraudulent and wrongful trading of 66 is also covered under 47, right? So only difference 47 is different from the other sections is that it is made by creditor, member or partner of the CD or the CP, corporate person, and not by the liquidator or RP. That is the only difference it has. Rest of the section is nearly similar to the avoidance transactions. But here, another language change which has been brought by this over the previous 47 is that the avoidance, if such an application, it shall be disposed of by the AA in such manner, and the order shall be passed in such manner as if it was filed by the RP or the liquidator. And then they say, after passing an order under subsection 2, where AA is satisfied that the liquidator or RP, after having the sufficient knowledge or information or opportunity to avail the information, did not report such transaction to the AA, it shall pass an order requiring the board to initiate disciplinary proceeding. That was there earlier also, but some language corrections have been made, and now it is made amply clear. And because of these anomalies in the IBC, erstwhile sections, a lot of avoidable transactions already बहुत complicated होती हैं. I don't think many of the benches and the advocates, with due respect, most of us are not able to understand the entire transactions sometimes. When it is asked to explain the transactions, we are already, looking at the papers and trying to make an explanation for that. But now, since the law is clear, we will be clear with the facts now, and we will be using them for the best of the outcomes to come.
No, it has made, ma'am, it has made RP more responsible and accountable.
Yes.
Because if the RP fails to file application for any reason, is not able to detect those transactions.
But that was already
45.
there, sir. That was
No.
already there in 47. 47
if-
पहले से इतना ही खतरनाक section था.
हाँ.
हाँ
So,
जी.
but establishing trail will still be difficult because the action happened 10 years, 15 years back,
हाँ
7
जी.
years
For
back.
that, we have the auditors with us.
Yeah, and the timeline is very strict.
I
You
know.
That is
Yes.
the problem.
So
If
initial,
RP,
I think initial 2-3 months are very important in any CIRP, and if you waste them, you will never be able to match the timelines.
even if you don't waste them, you use them wisely. But to detect in the right perspective and file an application with NCLT will be a tough task, tough call.
Yes.
And any member, see, now they have allowed any member, every
Yes.
shareholder. If he
That
still
was
be
there
he is
earlier also.
he is
The-
privy of that information, which the
that
RP is not. Then it will be more difficult for the
Yes,
RP to save
RP,
himself.
one has to be, AA will have to be satisfied that either you had that information or you had an opportunity to avail that information. Now you will have to justify your stance that you did
Yeah.
have that information or you did not have the opportunity to avail that. And that language was persisting since 2016. It is not a new language. 47 was there, only some corrections are made. This was the very intent of legislature since the beginning. So 47,
Life
like
life
her,
has become more tougher for
नहीं, the
RP.
toughness has become more clearer. वो पहले से थी, अभी हम पढ़ रहे
हाँ.
हैं उसको. Okay,
So,
so
Amit, just one question here. So,
हाँ
like,
जी.
there is a jurisprudence that there has to be separate application for, let's say, section 43, 45, or maybe 50 or 66. So, is
No,
there any change regarding that? So, as per my understanding, there is jurisprudence, there separate applications
earlier
have to be there. So, that
jurisprudence,
has to fall in a particular category. So, like, if one transaction is there, so wherein, let's say, undervalued thing is also there and preferential thing is also there. So, what is there any change regarding that, or is there any intent of the government,
as
legislative intent is there?
yeah, as I explained earlier while we were discussing this, earlier we have understood from the evolving jurisprudence only that how the applications are to be filed, you know. Every NCLT, every NCLAT, they were explaining to us the procedure, the RPs were going back, bringing new application, filing afresh. That is why most of the avoidable transactions have not brought any result till now. Because we were not aware what the section wants. We were not aware, we are still not aware sometimes what the factual position is, what the transaction is. So there are two complications. The law was not very clearly written, and the legislature, the courts were trying to explain to us what is to be done in that. One side there was an auditor, one side there was a court of law, and the law was not very clear. Now the clarity has been brought in the code itself, and avoidance transaction section 43, 45, 49, and 50 can be clubbed together. 66 was always different section. It had to be filed through a separate application always. So
But Amit, so what you want to actually convey regarding this? So now you are saying that like avoidance transactions, section 43, 45, 50. So all these sections, one can file is one application for all these sections, or
yes.
we have to actually file separate applications for, let's say, 43, 45, and 50.
No, in my view, as I have seen through the previous judgments also, and this is exactly in line with those, this amendment is clearly in line with those judgments, that 43, 45, 49, and 50, in case 2, 3 types of transactions are falling under these sections, they can be clubbed into one application, and fraudulent and wrongful trading under separate application, because for that the mechanism of identifying is different, determining is different, and here the mechanism and look back period are different. So these can be clubbed in one.
But
Clubbed
there
in
have been,
one.
yes, but there have been various judgments, so which I can recall as of now, so which say that there has to be separate application for all these 4 sections of avoidance transactions.
But
So
sir,
that is what courts are saying actually. So can I actually have the maybe a legislative intent behind this, and can somebody maybe Udiraji explain the legal aspect of it? Whether we can have one application for all the avoidance transactions and a separate
I
application
can
for the fraudulent one.
One application, but separately giving transaction under section
amounts
43,
are to be
45,
given
and
separately,
50.
transactions are to be explained separately. Yes.
my
Separate.
my
So,
my
That's what.
understanding.
Udiraji, what is your view?
Because,
Or
sir,
anybody other?
I
sir,
will
sir,
go back to the case
the
of
nature
Anuj
of the
Jain.
application, the nature of the application is categorically differentiated, no?
In Anuj Jain's
Please
case, Supreme
let us
Court
allow
has
Mr. Udiraji to speak, please.
what
Yes,
what has
Udiraji.
happened in Anuj Jain's case. It was held by the Supreme Court that the nature of transactions under 43, 45, and 66 are different and they have distinct ingredients. So they say that a common application ought not have been filed by the RP. That is what Supreme Court has held in Anuj Jain's case. As Harmiji has said, yes, people do file common applications for avoidance and separate for fraudulent. However, I have been following a practice after Anuj Jain's case. Before that, I used to also file common applications, and I did not face any issue. But after this Anuj Jain's case by Supreme Court, I have following that separate applications are filed under 43, 45, 50, and 66. Of course, 66 are always filed separately, but other applications also I have been filing separately. And the position of Supreme Court in this has not changed after Anup Jain's case. That is old case. This has been referred to in a recent matter also, in the matter of Texorange Corporation Limited also, in which also it was held. That is a 2024 judgment that separate applications have to be filed. So better to be cautious according to me and file separate applications, because
So Udaraj, is there any legislative intent while actually they have made changes in the definition? So like they are saying now this is avoidance transaction, section 43, 45, 49, 50, and these are the fraudulent fraud trading transactions.
There, sir. This was since the beginning of the code, this was there. Now the clarifications have been brought in.
Regarding applications or whatever, clubbing of these very things like avoidance transactions in one application.
For applications, I think we should follow the indications that will be given by the bench in couple of matters. And we will be very clear as to how it is to be followed, because I would not want to follow indication in the amendments only, because in amendments they are doing it clearly two ways. One is avoidance and one is fraudulent. So they are separate. However, I will still go ahead and file separate applications.
Okay.
That is what I would do personally. But as Harmeet has said, it can be done in that way also.
All right, let's move on. Section 26 also talks about the avoidance applications, but earlier again it was vaguely written that filing of an avoidance application under so-and-so shall not affect the proceedings. This was having a meaning. We were following it. Similarly, 44A or 42A regulation is also there in liquidation regulations, which is also very clearly saying the same thing. But now they have made it amply clear by explaining this a bit further. So it says avoidance transaction or fraudulent or wrongful trading under 47. Filing of such an application shall not affect the proceedings of CIRP or liquidation process, as the case may be. So this is only a clarificatory one, and this is going to help a lot of us. Insertion of a new section 28A. Now, this is again an important section, and this is going to bring a lot of practical challenges on how we are going to do it. In one way, it is very a welcome change. Theoretically, I find it to be a prudent one, but practically it will have its own challenges, and it is going to be time consuming initially, because sometimes COC won't understand, sometimes COC won't agree to it. So let us see what the code wants, what the government wants here. Where a creditor of the CD has taken possession, so there are preconditions to it. One, possession has already been taken. Two, they have the security interest and they have taken the possession. So two steps, they are already there. Of any property of the CD, of the CG or the PG, right? In 2021, Ashish sir is not here in the webinar today. We took his legal opinion only in one of the matters we were dealing with in the liquidation. The land was with the promoter. The land was owned by the promoter, and the plant and machinery was owned by the CD. And we were running an auction for the plant and machinery, which would have fetched a better value if it was sold along with the land. So we took a special first, we took a legal opinion from sir, and Ashish ji very clearly said, yes, this is possible. We serviced that to the bank. Bank also agreed, the lender bank, the FC, the SCC member, he also agreed that we shall issue a common notice of SARFACI plus the auction notice under liquidation. So that could have fetched better results. But in the meantime, the promoter started his own PIRP. He filed an application, and that is how he saved his land. But this was doable earlier also, had the bank understood it. But now the code specifically allows you to do it, that if a property of the corporate guarantor or the personal guarantor is with the same secured creditor of the CD, of course, they will be with the same person or CD creditor only, because the security has been created to them for the loan of the CD itself. if they have taken possession already, then the property can be taken up in the liquidation estate or can take form part of the resolution plan. So how it will help us? It will help us in fetching a better value and helping the situation, helping the resolving the situation of the city, maximizing the value. But at the same time, practical difficulty would be taking special approval from the COC of the CG or the PG if the matter of insolvency is going on for them as well. So that is the practical challenge. And I think that is going to be a huge challenge for all of us, since we don't have common RP.
Abhijit, so I just want to add here, let us say if that very PIRP is admitted, so
Yeah.
then the creditor has
Hmm.
always got the right to whether to forfeit their interest in that very particular property.
Yeah.
So and
So
that is also there in the forms with the Section 95 application. While they file that very application,
yeah,
that
yeah.
is
So
always
they
there
have
in the form
right.
as well. So
They
whether they
have
want
that
to opt for that very forfeiture of the property or not.
or
So accordingly
not.
things, yes.
This
So
shall be applicable only in the cases where the creditor has forfeited or relinquished its right. Right?
Yes.
Only in those cases that property can be included. If they are
So,
having exclusive charge, they would find a better value by selling it themselves. They may not
so
relinquish
then,
their right.
yes, like you said, that lender agreed. So if
Yeah.
the lender agreed, then they can always actually they would not like to relinquish that very property for the repayment plan.
So
So
that
that
is
can,
their decision. So
yes.
two decisions are practically important. One, that particular lender who has exclusive charge on that should have relinquished the right, and the entire COC ka 66% should give an approval for this. And problem is, in the personal guarantee matters, in the PIRP matters, the approval has to be 75% of value of the voting share of the CSC. So
Yes.
so that will have to be with the 75% there. And in case it is a corporate guarantor and CIRP is already going on, then 66% of COC of that CIRP also. So practically this will be a challenge, but this is interesting, and theoretically I find this to be logical and prudent to maximize the value.
Arvindraji, okay. Now, 1st of April, CIRP admitted,
Okay.
and which is supposed to be 180 days, 30th September. And in July, you have find that, yes, there is an interlocking assets. You are initiated PAP on the guarantor, which is again get admitted on, say, 30th September.
Mhm.
Then the moratorium starts,
Yeah.
6 months
Yeah.
minimum.
6 months. Yes.
How do you interlock all these things? It's a
Sir,
stupid
for it,
arrangement.
we
No,
will have
1 minute. Let me complete. 30th September, your CIRP is getting completed. By that time, this order come for the promotion, personal guarantees. Now you can get for another 3-month extension. But of 30th September, you are having received the order on PIRP with a moratorium. How can you touch the asset of that PG when the moratorium is in power?
That change will have to be made in the PIRP process also, sir. That cannot be taken up. If the code is being modified, it will have to take place at all.
It is not that simple as we are discussing
That's what
right
I'm
now.
saying.
Yeah,
That's what
that
Which
I'm
is
is not
having
simple.
a,
is going to be
Yeah.
challenging.
yeah.
It is going to be
Let
challenging.
me add a couple of points here. It is not as
Yes, Mr.
simple as
Oberoi.
Mr. Vinod has pointed out. There is far more to read in 28A according to me. I will take you back to the matter of K. Shashidhar, wherein it was very clearly decided that when the dissenting creditors decide to not to vote for the plan, they have made their commercial decision and they have decided to not to board the bus, and they have decided to go away with the liquidation value that they will get. That is part one. Part two is it was also expected, according to K. Shashidhar, that the dissenting creditors would walk away with the securities, guarantees, etc., that are available to them other than the CD's assets. So CD's plan the CD's plan, so far as the CD's assets are concerned, will be binding on everybody. However, it was expected in case Shashidhar that the dissenting creditors would be able to walk away with the collaterals that they may have, some exclusive assets they may have, etc., etc. We will not go into that. It will take a lot of time. But that was the general idea. However, recently what has happened, in many cases, the resolution plans have started coming where there is provision of assignment of debt. Now the question arisen in such cases was whether such an assignment will also be applicable to the dissenting creditors or not. And it has been held by NCLAT and Supreme Court while keeping the issue open. The orders of Supreme Court are very unique. They say that we keep the issue open. However, we say that assignment date is okay and dissenting creditors will have to lose everything, including the CD's assets, including the personal guarantees and any third-party guarantees that they may have. So this question was put up to the government in many representations by the bankers that if assignment date is happening without our consent, so assignment in date in itself is not a problem. However, what dissenting members were saying is it is happening without my consent and we are getting tagged and dragged along with the assenting members, that to the extent of CD's assets are concerned, they say we are okay. However, the PGs and the third-party securities that we hold, we are not being paid anything for it. What we get is liquidation value. Liquidation value is liquidation value of the assets of the CD. And the assenting creditors may be getting something more for the PG. They might be getting something more for the assignment. They might be getting something more for the third-party securities as well. So this question was a very big question. So if you read the language of section 28A, COC will be able to decide by 66% only when the creditor wants it. So now if the resolution plan provides for assignment, it will mean that the creditor who is likely to dissent, his assets or third-party assets or PG's assets might be included in the plan. So if the creditor agrees to it, then only it can be included.
Yes.
Otherwise, it cannot be included.
So
So that is
boils
what the
down to-
interpretation I will put it. I have
Those-
faced such issues. I'm fighting one matter in Supreme Court and one at NCLAT Delhi. And this issue has been put up and it is being appreciated by the bench that tag and drag cannot happen just like that.
Yeah.
And this 28A might be able to plug that loophole.
Yes, sure.
So, sir, in this regard, let us say if that very thing is put up in RFRP, and if a certain creditor has got the exclusive mortgage on a PG property, and if they know that yes, the plan will come, and accordingly that very particular amount which pertains to that very mortgage property of the PG, so if that will go to the exclusive mortgager or mortgagee, I would say, then they will agree to it. Why would they not agree?
Sir, it is not about whether they agree or not. At present, what is happening is without the agreeing, that is being snatched from them. That cannot happen. So even today, if there is a special security or exclusive security, resolution plan can provide that we will offer the value of the exclusive security to that particular lender according to 53(1). That is possible. And that plan can be accepted by AA also. There is no problem in that. The problem comes when you are paying liquidation value of the assets of the CD in the percentage of voting to that particular creditor. One, exclusive security. Second, there are some specific mortgages of guarantors made to that dissenting creditor, which also he is required to give up because he is dissenting to the plan and he is not getting anything for it. So that will be plugged possibly by this section 28A. That is what we are expecting.
But
Another
sir,
question which has been raised by Vinodji is when there is a mismatch between the CIRPs. One CIRP starts on day 1, one CIRP starts on day 30, PIRP starts on day 45. What to do? So
that's the reason. And another thing, sorry, sir. Simply on the admission of the PIRP, you cannot touch the asset of the PG unless he is in bankrupt.
Yeah, agree.
Bankruptcy start. It's a very big time travel. Okay.
So
I don't know.
So that is what we are expecting, that it will be amended. And there has been amendments on PIRP also that we are unfortunately not covering today. So maybe in the next session, we will see as to how the rights of the corporate guarantors have been reduced. But that is for another day to discuss. I will only discuss that in one of the matters that I was handling, one was a holding company admitted on day 0. One subsidiary admitted minus 15, that is 15 days before, and other 8 subsidiaries were admitted in next 6 months. So with COC's resolutions, we approached NCLT Principal Bench Delhi, and we got the whole process realigned, and we issued Form G again, of course, with a delay of 4 months. And we did procedural coordination in that, in group insolvency. And we successfully ran that process. But of course, as Mr. Vinodji has said, there was a delay. We couldn't do it in 180 days. So
Sir,
thereafter, we ran that as a group insolvency.
Anyway, this bill is in front of the
Yeah,
selection committee, na?
fine, Vinodji. I think you will have to send the questions on the group and we'll take them up
Yeah.
separately because we will
No,
not be able to complete the session on time today.
Actually, madam, I'm thankful to that, but I tell you, this bill is under selection committee, no? This bill is referred to the
Yes.
selection committee.
Yes.
So
Yes,
many
yes.
bills are now went to the JPC and all, correct? So understanding the degree of barometer in Delhi, I don't think that nothing is going to happen in another 1 year.
So
No,
leave that to
Vinodji, one
what
should be
happens.
hopeful, Vinodji, and let us continue with the session.
Yeah. So
Yeah, that all are okay, Sandeep. You know, I'm always there. But see, the thing is, nothing is going to happen in 1 year. Understanding the barometer pressure of Delhi.
all
So
right.
let us, Vinodji,
Harviji, the
people
other
should be,
challenge is the
professionals should
value.
always be hopeful.
Yeah, Harminji, let us continue.
Yes.
Yeah,
So
please continue.
Harviji, the
Please
other
continue.
another
challenge is the
important
value.
change. Let's
Yes.
quickly do that, and I may have to leave certain sections today. This is important. This one should not leave. Important is the dissenting creditors used to create a havoc, and most of the litigations at the time of plan approval used to come from that. And this shall plug that situation because now it says that payment of debt to the financial creditors who do not vote in favor of the plan in such manner as may be specified, which shall not be less than lower of the amount. So it is now lower of the two. It is very clearly said to be paid to such creditors in the event of liquidation, or that would have been paid to such creditors if the amount to be distributed under plan has been distributed in accordance with order of priority of 53. So this shall be very clear now, and I hope many litigations on this basis which used to disturb us would now settle down on their own. So minimum threshold for payment to the FCs, the dissenting ones, shall be lower of the actual liquidation value and the amount to be distributed under the plan. So plan value, if distributed in accordance with 53, and whichever is lower has been added over here, and the impact shall be minimum amount. Since it is now decided, then they shall now not obstruct the approval of the plan which is otherwise feasible and viable and approved by the COC. So that is an important change. Another change under section 31, which is not really going to impact us much, is yes, practically yes, but let us see how it goes because it is a peculiar kind of change that has been made. The NCLT shall first approve the implementation of the plan and thereafter approve the manner of distribution. Right? So first is AA may, before rejecting the plan, give notice to the COC to rectify the defects. If they are apparently on the face of it, then the defects can be removed and the plan approval is given importance rather than rejecting the plan and going into liquidation. So this is coming out of the recent liquidation judgments, which one has been overturned and the other has been implemented in JET, as we have seen. So much of work has been done in the direction of resolution and implementation of the plan, and thereafter liquidation has been imposed on that. So these are coming out of that. So correction window will be given to the COC. Implementation of plan. So first the plan will be checked with respect to 30 subsection 2. and thereafter the manner of distribution shall be checked separately in 30 days. So that will help all the stakeholders to get the real feasible plan implemented properly, and the litigations will also be minimized because of this. That is how I understand about it. Second important change is, I think that was again a mistake, because CCI approval was earlier in 31 subsection 4 was given prior to approval of the plan by the COC, and that was a major flaw in the law. Prior to approval by the COC, how can the RA bring an approval? But this was causing impediment in approval of many plans, and now it has been corrected to a situation where before the plan is submitted to the AA under 30 subsection 6. So that has been a
So
correction.
Harmeet, you can continue for 10 minutes from here. So you can continue, and then we will be starting the conclusion of the session.
Sure, sir. So I'm trying to quickly take up the important ones only. Where the AA approves the resolution plan under subsection 1, unless otherwise. So these are clarificatory points which have been added under 30 subsection 6. And I'm sure this will bring down the number of litigations at the stage of final plan approval. Plan approval is an important stage. See, admission and plan approval, if you could see the statistics, which is very evident from the IBBI newsletters also, and otherwise also we get the news. Plan approval and admission are two important decisions which NCLT is taking so much time to do that. And why is there is a time lag between in these two activities? Because of the litigations, most of which are frivolous and time consuming and wasting the time of all the stakeholders, and decreasing the value of entire process itself. The outcome is not there. So these clarifications will try and plug in the plan approval stage delays also. It says that unless otherwise provided in the plan, any claim against the corporate debtor, its assets under any law for the entity prior to the date of approval shall be extinguished. No proceedings shall be continued or instituted against the CD or its assets on the basis of such claims, including proceedings for assessment of claims. Now the bifurcation has been made via explanation 1 and 2, and it was important to bring it in the law itself, although jurisprudence has also clarified this through many of the judgments. It is clarified that nothing in this section shall affect a claim or proceeding in respect of a person who was a promoter or in management. So those proceedings shall continue, but CD shall be absolved. So this has been made quite clear. Second important explanation is that if a person has a joint liability or joint or several liability with the corporate debtor, for example, PG or the CG, for payment of debt owed to a creditor before the approval of the plan, and such person makes a payment for such debt after the approval of the plan, then any right of the person to be indemnified by CD shall be extinguished. So this clearly brings in the fact that right of subrogation shall not be granted to the guarantors. Right? So this plugs that anomaly also. There are certain definitions which have been amended, and this one is important, and I'm sure most of us have by now understood that rainbow judgment was not wrong, because it actually captured the anomaly in the section 53 language and the secured interest ka language. Now a clarification has been brought in both the definition of the security interest as well as section 53. So now it is very clear that whichever security interest has been created by a specific act of the parties, for example, an arrangement, an agreement, an MOU, hypothecation, mortgage, etc., charge has been created by themselves by the act of the parties shall be a secured charge, and not merely by the operation of law, for example, giving authority to income tax or GST. Those shall not be treated as a security interest. In the definition also, and in section 53 also, this was highlighted by Rainbow and has now been corrected in the IBC. Plan ka definition has been changed to include something very important which we might not have noticed till now. The simple words of sale of one or more of the assets of the CD has been added to the definition itself. And that was already captured by regulation 36(1)(a), which asks you to get to sell the asset or the CD or both of them. So regulations were amended already. Code is now being amended. So plan can also talk about sale of the acquisition of the assets of the CD, either on assets basis or the whole CD or both of them. So that has
Let me
been
add something there. Yeah. In case of addition of the word sell, I would draw your attention to one more very important proposed amendment in group insolvency. What happens in group insolvency? There is always a likelihood of subsidiary being commercially connected to the holding company only with regarding a particular division or particular asset. And in the group insolvency solution, it might be required to carve out that division or asset only, and the rest of the subsidiary or associate can survive, or it can continue, or it can be liquidated. So that wording was always there in the model law on group insolvency by UNCITRAL. However, those words were not incorporated in IBC. So when we are now moving towards group insolvency, this change will be very useful.
Yes. So this
Yes,
is
yes.
project-wise insolvency or assets to be sold separately than the entire CD. So this has now been incorporated in this.
Yes. So in this regard, actually, I just want to add that let us say some non-core assets are there. So let us say let's say some farmhouse is there or some other non-core assets are there. So those can be sold off, and accordingly amount can be paid up by the SRA.
There are two things here.
Hmm.
How the non-core and core assets will be defined?
So this is actually you can say that one
What
is
is
a
the-
productive asset, other is not a productive asset. So like I said that there might be a productive asset which is actually a facility wherein production was being done, and there is another asset which is actually a farmhouse in the name of the CD.
No, sir, suppose there are 4 plants. One is operating at loss, other is operating at profit. And the SRA feels the other which is running at loss is non-core assets. I want to sell it. Is it non-core? So
The
there will be,
option is given.
SRA will not be, SRA may not be able to do that on its own. It is expected that the COC and the RP will give some kind of guide to that
Yeah.
effect in the RFRP.
Yes.
Yes.
And that RFRP will guide the RAs to come accordingly. So the guide will be the COC and the RP.
Yes.
It will be
As
there
I
to
have
identify such assets.
I would request, Anil sir, I would request you and others also to look at the amendment which has been brought very recently in May 2025 itself. And that talks about, in the CRP regulations I'm talking, while getting the eligibility criteria approved, while going for the EOI, while going for the Form G ka approval from COC, RP will have to ask the COC and get it approved. There are 3 options given in that, either CD as a whole or the assets or both of them. So the COC has to now approve this as well. So RP will present the case, COC will approve or not approve the manner of sale, and thereafter that will be offered as it is in the Form G itself.
Okay.
So that starts from that level now.
And now regarding the earlier change which you discussed about the rainbow, the secured creditor, government liabilities, if there is a contractual agreement signed between tax department and the CD, then it will become statutory liability or contractual liability.
Contractual.
Ashish ji also in the seminar said.
Statutory liability, because in section 53, there has been an explanation which has been inserted, which we can go to. In that, it is very clearly stated that whether contractual or not, government liability or government dues will remain government dues. So that has been taken care of in section 53. So that has been appropriately addressed. Your question is correct, Anikji, that there can always, government can change their forms and say that the VAT liability will be a contractually payable liability, but that has been taken care of in section 53 explanation which has been inserted.
Okay,
So
thank you.
shall I share that on the screen? It is right there.
Harmeet ji, we have to wind it up in another
Yes,
1 or
yes,
2 minutes.
Yeah, sure. All right, so there is not much left in my presentation. Voting share has also been clarified, and Earlier, people used to have litigations and questions on the subject that whether unrelated parties, if they are related parties, if they are FCs, will their share will be counted. So now it has been clarified that voting share means the share of voting rights of a single FC in the COC, which is based on the proportion of the financial debt owed to such FC in relation to the debt owed by the CD. So owed by the CD occurring at the end, the words to the members of the COC who are eligible to vote shall be inserted. So, the debt owed by the CD to the members of the COC who are eligible to vote. So only the members who are eligible to vote shall become the denominator now. Right? So that is clarified now.
Yeah.
These are about the overall impact. So I'm not going up.
So we will be covering it in the upcoming webinars.
Yeah.
So this was a wonderful session, and I would now request Mr. Parag Singhal to express gratitude and show mementos.
Yeah, sure. Thank you.
Shall I request participants to switch on the videos once and say cheese?
My video is not working. Otherwise, I would have put it on.
Thank you so much, sir.
I'm so sorry for that.
So
On
others may also switch on their videos.
So on behalf of IPNet, I extend my gratitude to Harmeet Kaur for being a lead speaker and carrying on this discussion. Formal vote of thanks will follow. We are presenting you this the memento in electronic format. It will be physically sent to you in due course.
Thank you so very much, sir. Thanks, everyone.
Moving forward, please allow me to present our gratitude to our own IP Udairaj Patwardhanji. And I must tell all the participants that both Harmeet and Udairajji are IPNet members, and we are delighted to have such wonderful speakers among ourselves. Thank you, Udairajji, for your unique legal analysis of the discussion.
Thank you for the opportunity.
Yeah, thank you. Paragji, many people are asking for the presentation. So if I can send it on the group or to you, or how?
Yeah, you can send it on chat box.
Okay, let me share it right away. And those who need it can download it from here.
Yeah. And last but not the least, our own Sandeep Chitkaraji for being such a wonderful anchor and leading the discussion from the fund. Thank you, Sandeep.
Thank you so much, sir. Thank you so much. But overall, this has been a wonderful session, and I was not expecting that this would be so interactive. And I think the time has passed like anything.
Yeah.
So yes, so still not many things are to be discussed, but we would be covering it in the upcoming webinars. And overall, this has been very wonderful.
Very lively
everyone.
session.
So
And
before moving forward, I would request Mr. Udairaj Patwardhanji to please announce the next webinar.
We will be holding the next webinar by IPNet West on 6th of September. We are still pondering on the topic to be decided. So it will be circulated in the early next week. And accordingly, please be ready to receive us with some new interesting topic again. Thank you.
Thank you, Udairajji.
Thank you.
If Sandeepji may allow me, should I extend vote of thanks?
Please go for vote of thanks, Paragji.
Thank you, Sandeepji. Friends, it is an honor to extend vote of thanks for today's webinar on behalf of IPNet. Today's event has marked a milestone. So far as the much anticipated new IBC regime is concerned, in the IPNet, we can proudly announce that we are providing opportunity to our active and willing members to come forward and join us as guest speakers. This was in fact one of the aim and objectives of IPNet, to empower our members in knowledge and ability as IPs. Friends, let me extend my heartful thanks to guest speaker and CS and IP Harmeet Kaur for the wonderful deliberations and knowledge sharing on the topic. I must congratulate her on behalf of IPNet for being happily available to support the IPNet initiatives.
Thank you.
I request IP Udairaj Patwardhanji to kindly accept our gratitude for being such a useful resource on the topic in hand. I extend my sincere thanks to him for the legal analysis done by him during the webinar and making it a powerhouse of knowledge.
Thank you very much.
I would like to express my gratitude to IPNet President Dr. Ashish Makhija. Ashishji's commitment and his ability to lead from front has made IPNet a much sought after platform of greater significance by the insolvency professional pan-India. The interesting topics on which webinars are being organized certainly make value additions in the knowledge and abilities of both the members and non-members of IPNet. I also extend my thanks to IPNet team for their seamless coordination and tireless efforts behind the scene which ensured a smooth conduct of the webinar. I'll be failing in my duty if I do not mention the name of IP Sandeep Chitkara, our dynamic anchor for the success of the webinar. Thank you, Sandeep ji, for successful conduct of the webinar.
Thank you, sir. Thank you.
Thanks to all and one present in the webinar in such a large number for making it successful by their enthusiastic and active participation. Your presence in the weekend webinars is testimony to the vision and efforts of IPNet. Thank you all once again.
Thank you, Parag ji. Thanks to you too.
Okay.
Thank you.
Thank you so much, everyone, for being good listeners and interacting with the team. So this has been a wonderful session overall.
Thank you very much.